Thank you. Ladies and gentlemen, it's really a great pleasure to speak to you today. As I've heard, you've had a very long and successful week of studies. And as Anna's already alluded to, my subject matter today is quite troubling. And indeed, Anna and Jarek were really sadly very prescient in having picked this topic for me some weeks ago, long before we knew that we would be having a very hot conflict breaking out this week. Indeed, when they chose this subject, we were already at a state where the number of armed conflicts globally had reached the highest level since World War II. You'll know that the most severe conflicts based on impact and scale around the world include the war in Ukraine, the ongoing Israeli-Palestinian conflict, conflicts in the Middle East and North Africa. Now, these tragic developments bring suffering to the populations, but they also, of course, interrupt international commerce, trade, and investment. And the aftermath of these wars, or even in the midst of them, we are very likely to see disputes brought to international arbitration regarding the economic impact of these armed conflicts. Today's wars also may create new avenues for business, such as in reconstruction. And in the past few months, we've also seen how wars may be used opportunistically to further other business objectives, such as the acquisition of resources. A serious subject, but occasionally we can bring some levity even to serious subjects, as this cartoonist has done, and I can tell you that he was very pleased to let me use his cartoon. I have not just stolen it off the internet. This cartoonist on his website, when he displays this cartoon, he asks if the Ukraine-US minerals deal is the product of extortion in the guise of diplomacy. So we really might wonder if we are seeing a change in paradigm. Are we entering a new era in which business opportunities are seized through violence and wealth is extracted through the imposition of power? And indeed, are armed conflicts going to be a tool of commerce rather than a barrier to it in the years ahead? Now, this pattern will sound familiar to students of international economic history. You will recall that during the 18th and 19th centuries, we had chartered trading companies who were actually mandated to wage war in order to expand the commercial interests of European powers. Some have called this war capitalism. And as late as the beginning of the 20th century, we had states using military force to protect the foreign investments of their nationals. A classic example of this, and I forgot to start my timer, a classic example of this so-called gunboat diplomacy took place in 1902 when Venezuela was subjected to a blockade in response to its sovereign debt default and its refusal to honor the demands of bondholders from the UK, Germany, and Italy. Now, international arbitration even played a controversial role in that Venezuelan crisis. The dispute was referred to the Permanent Court of Arbitration in The Hague, which concluded that the blockading powers were entitled to preferential treatment in the payment of their claims. This left other countries that did not take military action, including the United States, with no recourse. As a result, US President Teddy Roosevelt adopted what came to be known as the Roosevelt Corollary to the Monroe Doctrine. And that's what you see illustrated in this cartoon. I'm afraid this is in the public commons, so I didn't get to correspond with the cartoonist. This cartoon, though, illustrates the what came to be called really Teddy Roosevelt's big stick, or in this case, it was a big gun. And it was the policy of the United States to intervene militarily, particularly in Latin America, to protect American investments. And not only was it the policy, it was the practice quite regularly. And this went on until we had the other Roosevelt, Franklin Delano Roosevelt, overturn this practice with what he called the good neighbor policy. Now, you'll note in the quote that I have on the screen, that is Roosevelt presenting his policy to the US Congress, and there is an emphasis on the sanctity of agreements as well as on the rights and duties, well, the rights primarily of the neighboring countries. We've lost my slides, but anyway, I'm going to move on, and I promise you that on the slide you will see that we're going to talk now about the rules-based international economic system. So war also played a really constitutive role in shaping the rules of international economic law and international arbitration. The devastating effects of World War II inspired the creation of the Bretton Woods institutions, including the World Bank, which since the adoption of the ICSID Convention in the mid-1960s has, of course, housed the International Center for the Settlement of Investment Disputes. The need to facilitate international trade and investment following the Second World War also led to the adoption of the New York Convention, which I'm sure you have heard a lot about this week. And since then, international economic law and international arbitration have supplied alternatives to armed conflict and territorial conflict, conquest, as a mean of accessing resources and protecting acquired rights and assets of investors. Now, it's true that this international system does remain grounded in the legacies of imperial and colonial conquest. It's also true that the system is in many ways still coercive, and it is designed to promote the interests of powerful states and their multinational enterprises. Nonetheless, international economic law and arbitration still have much to offer as key components of an institutional framework predicated on the peaceful rather than violent resolution of conflict involving economic rights. So against that backdrop, that worked. In this lecture, I'll aim to cast light on how international arbitration deals with armed conflict, highlight some of arbitration's strengths and weaknesses in that regard. My lecture will proceed in 4 parts. First, to further set the scene, I'll provide a quick overview of the typologies of armed conflict and the many roles that corporations can play in armed conflict. Second, I will focus on investment arbitration and consider how it deals with armed conflict. Third, I will focus briefly on international commercial arbitration and how it deals with armed conflict. And finally, I will share some thoughts on the path forward and the future of arbitration in this era of global instability and escalating conflict. Now, in terms of the typologies of armed conflict, we have international humanitarian law provides a definition. This definition applies to a relatively narrow set of circumstances. An armed conflict in this case needs to be of sufficient intensity and also involve armed groups with a requisite level of organization to be covered by international humanitarian law. Still, in theory, businesses affected by armed conflict of this nature could seek protection under international humanitarian law, which I'm going to call IHL for short going forward, because businesses would ordinarily qualify as civilians. And IHL imposes obligations on warring parties, such as distinguishing between civilian objects and military objectives, also taking precautions against collateral damage to the former and limiting attacks to the latter. And it also requires parties to respect the principle of proportionality. Now, IHL also prohibits the forcible taking of private property by an invading army or conquering army for private or personal use, meaning pillage. But despite these requirements, IHL protections are really not very robust with respect to economic interests of foreign investors. And really, they're very rarely invoked in that context. IHL prohibitions on destroying civilian property focus on protecting livelihoods and on mitigating human suffering, really more than they focus on ensuring respect for economic and property rights. So if we talk about the typologies of armed conflict that we actually see in practice today, there's a broader range of conflicts that I think businesses get caught up in than those covered by IHL. Really, we see, of course, international and internal wars, and sadly, we see more of those all of a sudden than before. But we also see companies, including foreign investors, getting embroiled in lesser instances of civil unrest and also in conflicts relating to organized criminal activity. And international economic law does not define armed conflict. Sorry. all different types of armed conflict might be covered by the protections and defenses provided for in international investment treaties and commercial contracts. Therefore, it's to these instruments that businesses usually turn for protection and reparation with respect to armed conflict. So I should note that the typology on the screen also rather downplays the role of corporations or private business actors in using or encouraging the use of force, or in waging wars or otherwise benefiting economically from violence, and that's something we'll talk about. Again, sorry, this is the many roles of the corporation. The corporation in international economic law is usually situated as a victim of conflict, either in an unstable host state or as a victim of an aggressor host state. Very rarely do we see much discussion of the role of the corporation in fomenting or benefiting from armed conflict. Okay, so turning to international investment arbitration, which is why we're here. I do want to note one thing as a preliminary. Armed conflict does not tend to displace investment treaties. In other words, the International Law Commission's draft articles on the effects of armed conflict on treaties indicate that there is a presumption of continuity in treaties. I won't go further into that, but we can say that investment treaties do continue to apply in the context of armed conflict. A provocative thing to say, but it's really just something to think about, is the question that some have raised as to whether that new U.S. minerals deal that I flashed up on the screen, or the cartoon that we talked about, whether that minerals deal might be susceptible to claims of invalidity under international law if one could argue that it was the result of coercive pressure from the United States leveraging the armed conflict by Russia. But that is a controversial subject that we will set aside for today. In any event, there is a Ukraine-US bilateral investment treaty, which would not be susceptible to such claims. And that treaty, like many other investment treaties, contains clauses referring to losses owing to war or to other forms of armed conflict or similar events. Some years ago, co-author Maria Fogastam-Agius and I wrote a book chapter, which I'm not going to reach for because I might get tangled in this cord. It doesn't matter. There's a book. I'll show it to you guys later. She and I wrote a chapter in this book looking at war clauses, and the book is called International Investment Law and the Law of Armed Conflict. And we found that there was a typology of clauses that really could be characterized as three different types of clauses. The first are compensation for losses. The second are called extended war clauses, and the third are strict liability war clauses, and these are sort of situated in order of descending frequency. So you see the first very often, the second not so often, and the third almost never. But let's walk through each type. Now, compensation for losses clauses, and this is an example on the screen from the Germany-Russia bit. Most of these clauses provide for national treatment and most favored nation treatment in relation to any measure such as restitution or compensation that states may take in relation to losses owing to war or other forms of armed conflict. Clauses of this type do not create any absolute rights to restitution or compensation. All they do is promise non-discrimination in case there already is a program of indemnification of some sort. Now, one strength of these clauses is that there's no need to prove who caused the damage, and hence no need to attribute acts of violence specifically to the state. However, these claimants do need to prove discrimination, which can be very difficult from an evidentiary perspective. Now, some of these compensation for loss clauses go further and also talk about guaranteeing fair and equitable treatment, or that compensation must be adequate. But in reality, most of these clauses don't offer a huge amount to investors who have been affected by armed conflict. They operate really only in case the state's already instituting a sort of a mass program of compensation. Extended war clauses, however, essentially take the compensation for losses clause that I already mentioned, but then continue on, extend on, and offer more robust protection. These clauses typically include a compensation clause that's absolute So on the screen, you can see an example. So that losses suffered by investors at the hands of a host state's armed forces or authorities through A, requisitioning, or B, destruction not required by the necessities of the situation, are treated by analogy to expropriation. So in other words, such acts require compensation that's prompt, adequate, and effective. You'll see from the language also that these clauses do require that the host state, sorry, I've lost my page because I've been attacked by a small fly. Give me a moment, where was I? Right, yes, compensation is due only if the loss was caused by the forces or authorities of the host state. So rebel forces or foreign military forces are not covered. And you can see from the language the duty to maintain restitution or pay compensation in the case of requisitioning does not hinge on military necessity. Compensation is due regardless, even if the requisitioning was necessary, you still have to compensate. By contrast, in the case of destruction, restitution or compensation is due only if the forces acted in excess of military necessity. In other words, collateral damage arising from military action that is lawful under the laws of war need not be compensated. That means that arbitration practitioners and tribunals, and this is a bit of a warning here, dealing with these clauses should be familiar with the laws of war as codified in the Hague and Geneva Conventions. And I will come back to what those conventions say later. Now, claimants invoking the destruction prong of these clauses will bear a very heavy burden of proof. They will have to show, again, that the destruction was not required by the necessity of the situation. Proving a negative is never easy. If any of you as practitioners have tried that, it's never very fun. And some argue that, in fact, the burden in this case really should rest with the state. But it does not in investment arbitration in this case. It rests on the investor. The situation is further complicated by the fact that often the evidence is subject to military, it's classified for national security reasons. So these are difficult cases to prove. They also raise a broader interesting question as to whether sovereign states really did consent to having arbitral tribunals second guess their military tactics and imperatives. So as you would imagine, respondent states often argue in these cases that indeed the concept of military necessity should be self-judging. And that would be the case under international humanitarian law by and large. So this position has been rejected by investment tribunals, but it's worth noting that it is one that could still be contentious in the cases of the future. Now, there are several well-known cases in which arbitral tribunals have grappled with extended war clauses. The first was called Asian Agricultural Products versus Sri Lanka, or AAPL, I will call it in the future, which involved a counterinsurgency operation during Sri Lanka's very long, nearly half a century civil conflict. In a small Tamil village, there was a prawn farm that was the main source of livelihood for local villagers. In January 1987, armed forces stormed the village, rounded up the workers at the farm and the villagers who happened to be there, took them to a nearby road junction and shot them all. 80 civilians were killed and the farm was burned to the ground. The foreign investor who owned the farm brought a case against Sri Lanka demanding compensation for its destruction. The investor based its claim on the extended war clause and the full protection and security clause, which I'll call the FPS clause for the future. It claimed that that the war clause and this was in the UK Sri Lanka bit, I should say. Anyway, the tribunal, with regard to the extended war clause, said that the investor had to prove that government forces and not the rebels had caused the destruction, and also that the destruction needed to be shown to be as a result of combat, and also that there needed to be no military necessity for the destruction. And the tribunal found that the claimant could not bear this heavy burden of proof and dismissed the claim based on the extended war clause. I'm going to come back to this case later, though, so you'll see. Some 10 years later, American Manufacturing and Trading, or AMT, brought a case against Zaire claiming that its warehouses were looted and destroyed by Zairean soldiers. It's interesting to note here that AMT invested in the distribution and sale of security-related equipment. So that is what was being stolen. Nonetheless, the tribunal applying the extended war clause concluded that the soldiers in uniform had actually acted individually, and therefore the state was not responsible. So they lost once again under this extended war clause. Now, the third sort of famous case is more recent in Strawbag versus Libya. Don't think that's how you pronounce it, but a tribunal applied the extended war clause in the Austria-Libya bit, this time finding that it had been breached. The investor had construction and civil engineering contracts specifically to build roads, and it also had a fleet of heavy machinery and equipment at a construction site. And the claimant alleged that during the civil war in Libya, a significant quantity of its property had been looted and destroyed and never returned. And the tribunal found that in this case, actually, the claimant did meet this very heavy burden of proof and awarded compensation. As an aside, I was involved in one of these cases, not those particular cases, but a case against Libya in which we were trying to prove that it wasn't NATO, but rather the state that had destroyed the investor's facility. So you can see that these issues of proof are very difficult to overcome. Now, as you can also see, these extended war clauses have some serious limitations. Besides the evidentiary hurdles, they also are restricted to action by a belligerent state on its own territory. So they're really not that useful in international armed conflicts when you're thinking about states acting outside extraterritorially. Turning to strict liability war clauses, these are the very elusive and I think quite rare type of war clauses, but Maria and I did find some of these in Italy's bits with Yemen and Syria in particular, and we have the Yemen-Italy bit on the screen. These clauses impose an absolute obligation to compensate investors for damage that results from war or civil disturbance, regardless of whether the loss was caused by government forces or by non-state actors. These clauses, again, they're not only rare, they're actually quite unusual. They add very significantly to other bit obligations. And they also go beyond customary international law. And in fact, we can see that from two early cases that were brought against Venezuela before before World War II, and before we had this system of investment arbitration. The first was brought by Mr. Upton to the Mixed Claims Commission between the United States and Venezuela. Mr. Upton's small boat was destroyed when Venezuelan authorities seized it and used it against a much larger revolutionary steamer. The commission declined to award Mr. Upton any compensation for losses arising, and I quote, from the disturbed condition of the country due to the civil war then existing in Venezuela, on the ground that he had merely suffered the same harm as nationals. And then in the second case, which was brought by an Italian national, Mr. Sambiagio, to an international commission, the umpire refused to hold Venezuela responsible for the acts of revolutionaries, saying that this would be in derogation of general principles of international law. So you can see that this strict liability war clause is actually quite robust, shall we say, and probably stronger than what you would get under customary international law. Now, there are other relevant rules of investment law, and in fact, probably more important rules of investment law when it comes to armed conflict. During our study of war clauses, Maria and I found that respondent states often argue that the war clauses exempt them from the rest of their investment treaty obligations. But we also found that in most cases, tribunals reject this. They do not agree with the argument the war clauses are lex specialis and therefore supersede other substantive provisions of investment treaties. Tribunals tend to apply war clauses in conjunction with or alongside the other clauses of an investment treaty. So which other types of clauses are important in armed conflict. Clearly, expropriation and also fair and equitable treatment are relevant. But by far, the most frequently cited standard in relation to armed conflict is the Full Protection and Security Standard, or FPS standard. Most bilateral investment treaties contain the standard, so it is quite ubiquitous. And then we also find that there are essential securities clauses, which are also called non-precluded measures clauses in investment treaties. Only a minority of BITs and FTAs contain such clauses, but it's interesting to note that among that minority, there are a number of war-torn states that have these clauses in their treaties, including some of the Ukrainian, Libyan, and Syrian treaties. Now, customary international law may also be relevant in investment treaty cases, even in whether there's an actual clause in a treaty or not. For example, the ILC's Articles on Responsibility of States for Internationally Wrongful Acts lists several circumstances precluding wrongfulness. Of these, necessity, self-defense, and force majeure are the most pertinent in situations of armed conflict. Now, finally, and I'm going to talk about each of these things in a bit more detail in just a second, we'll also consider right at the end some of the possible impacts on an investment treaty claim of a state assuming responsibility or an assumption of risk, but also of an investor assuming some of the risk of operating in a zone that is already afflicted by armed conflict. So if we start with the very famous and most important clause, the Full Protection and Security Clause, this is not geared specifically towards armed conflict, as you can see. Nonetheless, it is often invoked. It indicates that a state has both a duty to protect and a duty to refrain. The duty to protect means that the state must defend the investment against violence by other actors. And the duty to refrain means that the state must exercise restraint in its own use of armed force. And an example would be in the Bywater Gaff versus Tanzania case. The tribunal wrote that the full security standard is not limited to a state's failure to prevent actions by third parties, but also extends to actions by organs and representatives of the state itself. So the obligation to provide FPS does not create absolute liability. It's an obligation of due diligence. That is, the obligation is limited to the reasonable exercise of the host state's capabilities. So if we return to the sad case of the shrimp farm in Sri Lanka, you'll remember that the extended war clause claim failed, mainly because the investor could not prove whose forces had destroyed the farm. However, the FPS claim succeeded because the tribunal found that Sri Lanka had failed to take all reasonable measures to prevent the destruction of the farm and therefore had not acted with due diligence. The tribunal also found that the force deployed by the armed forces was excessive and unwarranted by the circumstances. There again, you have the issue of an arbitral tribunal second-guessing the military judgments of a sovereign state. We can also return to the case in which AMT's warehouses in Zaire were looted and destroyed by soldiers. You'll remember that the extended war clause claim failed there because the tribunal concluded that the soldiers acted individually, and so the destruction was not attributable to the state. Nevertheless, the tribunal found that Zaire had breached the FPS obligation under the US-Zaire BIT by failing to take measures to ensure the investment's protection and security. Now, other cases also show how robust the FPS standard is in comparison with war clauses, especially when it comes to non-state actors. For example, in Ampal American versus Egypt, the tribunal found that the authorities' failure to protect the investment against terrorist attacks was a violation of the FPS standard. Also, we have some other claims that aren't sort of as directly related to armed conflict, but show how robust this FPS standard is. One example would be in Bear Creek versus Peru. Here, the claimant was pointing to acts of violence committed by members of the community who were protesting the investment. And that case was interesting because it showed how the conduct of the investor could be relevant to the assessment of whether a host state exercised due diligence in protecting an investment. This case was ultimately decided on the basis of expropriation, but the tribunal did consider whether FPS applied, and they split on the question of whether the corporation in that case was either a victim or actually a perpetrator of the armed conflict. In applying the FPS standard, a fundamental question is whether the due diligence should be measured against the conduct of a modern, well-organized state or against the capabilities of the particular state respondent. And in the Sri Lanka case, the tribunal held that the benchmark should be what they called a well-administered government, and that what that well-administered government could do in like circumstances was the relevant benchmark. By contrast, a sole arbitrator in a case against Albania stressed the importance of accounting for local conditions, including the state's fragility and limited resources. Now, to settle that question, it's interesting to note that some states have started to adapt their treaties. So the African Continental Free Trade Agreement Investment Protocol contains a modified FPS provision, which expressly states that the standard is subject to each state's capabilities. In the end, that's kind of a repetition of what customary international law already says. But I think the idea here was trying to emphasize the point that this should be more of a subjective standard, or at least a relative standard, and as opposed to an objective one. The cost of due diligence, regardless of which view you espouse in terms of the standard, the cost of due diligence can really be very staggering for any country at war. If you take Afghanistan, for example, the Metallurgical Corporation of China, the MCC, had a 30-year contract to extract copper from a mine that was subject to constant attacks by the Taliban between 2008 and 2014. The government spent hundreds of millions of dollars trying to protect that asset. Likewise, we'll see that Ukraine, if they do in fact start offering production sharing agreements to investors, and they did, by the way, open up a round of these only, I think it was last week, that will entail a lot of resources for them to protect those investors if they do start coming in, especially if the war is ongoing. Security clauses also are very frequent in investment treaties, and these reserve quite far-reaching discretion for states, and they can be seen in US Ukraine treaties, for example, on the screen. And they refer to the maintenance of or restoration of international peace and security. You'll notice this, of course, echoes Article 39 of the UN Charter, and means that actions taken pursuant to Security Council resolutions under Chapter 7 of the Charter should be covered by this exception. I should have got distracted and didn't tell you what these security clauses really do. What they do is allow states to justify action that is otherwise prohibited, including by the FPS clause or expropriation standards. Now, some of these treaties contain self-judging security clauses. In our case on the screen, it is not self-judging because, as you see, it uses the term measures necessary, which is an objective standard, and is inviting a tribunal to assess whether those, that was objectively necessary. Again, query, should tribunals not then know what military necessity is if they're going to interpret these clauses? But a lot of treaties also contain expressly self-judging clauses. They use language such as measures which the state considers necessary. And that will, of course, give much more discretion to the state that invokes this clause. By contrast, some other treaties limit the essential security defense to specific situations, such as situations of armed conflict between states, so international armed conflict, and the ECT is an example of this. Turning from specific treaty clauses to tenets of customary international law, we see that necessity, as articulated in the ILC's draft articles, may provide justification for a state's measures in times of conflict. Again, I've been sort of harping on this already, that military necessity is a key concept in IHL, and it's also subject to serious limitations in IHL, so it's wise to know what those are. In fact, you need to have shown that the incriminated act is the only way to safeguard an essential interest against grave and imminent peril. So if you are going to rely on that clause, you will have a very high standard of proof as a state. You also need to demonstrate that you as a state did not contribute to the situation of necessity. So an aggressor state is not going to be able to invoke this kind of clause. Now, the ILC in its commentary notes that these clauses will be only very rarely successfully invoked. Now, if we move on to self-defense, this is a kind of obvious one that a foreign investor may find that a state argues that whatever they were doing to the particular investment was done in self-defense. For example, if an opposing army was hiding in the investor's property or utilizing it as a base, then presumably a state might try to argue self-defense in the destruction of that property. It would also be hard, but not inconceivable, to make a defense based on force majeure, especially if there's a war clause, though it will be difficult because the war clause will be considered lex specialis, and to effectively make such a defense meaningless, it will be sort of the state assumed the risk and they illustrated the assumption of risk by putting in a war clause. However, if you do try to make a force majeure clause argument, you're going to need to show that that there was an irresistible force or an unforeseen event, that the event was beyond the control of the state, and that the obligation was impossible to perform. Again, must not have assumed the risk of this event. Now, the successful invocation of any of these clauses will essentially exempt the state from paying would not exempt the state necessarily from paying compensation. And that's clear from the ILC's articles as well, that if you have a circumstance precluding wrongfulness, it's not necessarily to say that you wouldn't have to pay compensation for any material loss caused by the event. Even if it was not a wrongful act, there may be an obligation to pay compensation. So I'm going to skip through some of these because I know Jarek now is eager, but I'll just say there are some other defenses beyond the conventional customary defenses. You can think about, we've already talked about assumption of risk. I didn't have clauses to show you, but rather quotes from case law. And I can show those to you because we'll send the slides around. But the essence of these case law citations are times when tribunals have noticed that an investor has gone into a high-risk territory and said, you, investor, have assumed some of this risk. There are quite a number of these outside of the war context, and the basic gist here is that investment treaties are not meant to be insurance policies, nor are they meant to sort of get out of jail free card for investors to go in without doing any due diligence on the circumstances they're getting themselves into. So these are the kinds of issues that could come up in these cases, including the investor's own contribution. And again, I cited the Bear Creek case, and that's the kind of analogy that I think you would maybe find if an investor had a role to play in provoking armed conflict. That might sound far-fetched, but I also do transnational tort litigation, and there are a number of cases right now through the courts, one in Sweden, one in France, against companies where they really were implicated in fostering civil wars or other forms of armed conflict. So it is not quite as unrealistic as you might think. Now, I'm not going to go through the relevant rules of international humanitarian law. In my lovely book, somebody else does that for me, so you can find that there. Likewise, the soft law standards for business that apply in armed conflict scenarios would, of course, be one of my favorite subjects, and I'm sure Anna would find that interesting too. However, time is limited, so I'm going to refer you. There's one chapter in there. And then there's probably many other things written on this subject. So you'll have my slides, and those will have to suffice for that subject for now. But we're finally, Jarek wanted me to mention international commercial arbitration, which is what you've spent the week on. So so now he's awake. To do that, I will just make a few comments about international commercial arbitration. The starting point is similar to in the treaty context. Because we're in a state of armed conflict does not mean your contract suddenly dissipates or vanishes. However, we do, of course, have contractual clauses that talk about what should be the actual outcome in a situation of conflict with respect to either specific clauses or the entirety of a contract. The most obvious one is a force majeure clause. These are, of course, ubiquitous in international contracts. They excuse performance when unforeseen events like war render a party's obligations impossible or impracticable. But the effectiveness of a force majeure clause really will hinge on its wording as well as how it's interpreted. So just to give one example of a commercial arbitration case, it's been widely cited because it's in the courts. There's a case between Larsen Oil and Petroprod. And in this case, the tribunal had to evaluate whether war and political unrest in Nigeria qualified as force majeure. But because the force majeure clause in the contract did not explicitly list armed conflict, the tribunal found that it had not satisfied the force majeure clause. So obviously the lesson for your corporate colleagues who are drafting contracts, language really matters. And if we want to be, if unfortunately we think that we're going to be confronted with more commercial contracts being interrupted by violence in the years to come, we should make sure our colleagues add such words as war, hostilities, insurrection, military action, etc., into the force majeure clauses. Now, material adverse change clauses, these are very common in share purchase agreements. You can envision that if suddenly the circumstances become one of war, would it allow a buyer to walk away from a transaction? Obviously, that again is going to be very fact specific, also very specific to the language of the contract. I think sanctions is an issue that will come up quite a lot in this context. If, for example, there's a transaction about to, I'm sure many of you will have advised on sanctions issues where a client's contemplating doing a transaction but is worried about sanctions effects. And indeed, a good thing to do is, if that is a worry, make sure that the MAC clause has a way to walk away if sanctions interfere. There have been some of these cases, of course, one involving a Ukrainian tech firm's acquisition during the current war, and the buyer argued that the war had triggered the material adverse change clause. Now, stabilization clauses, these are, of course, controversial, but also very common, especially in the kind of production sharing agreements that we're going to see in Ukraine. They protect investors from sudden changes in law or regulatory regimes. But this could, even though they might not be necessarily designed for this, this could be particularly relevant during or after a conflict, or in the case of a regime change, where governments may suddenly nationalize assets or restrict capital flows. And these are a kind of classic example. There have been a lot of studies of what stabilization clauses look like, but the kind of very classic one is just a freezing clause, which purports to lock in law at the time the contract was signed. Now, there are a lot of other types of risk allocation measures that could be deployed in contracts that could relate to war. I mean, obviously, termination provisions, reps and warranties that might be hard to fulfill if suddenly you're finding you're in a state of war. Similarly, covenants might, war might prevent parties from basically taking the actions that they were covenanted to take prior to the closing of a transaction. So in that way, war might interrupt transactions before they even get started. There's also obviously legal doctrines such as impossibility and frustration. I don't have time to talk about my favorite subject in Anna's of human rights and how human rights and humanitarian clauses could enter into contracts, but suffice it to say that if we get the EU's Corporate Sustainability Due Diligence Directive, then we are going to see a flurry of contract clauses because the CSDDD requires them. And it specifically requires heightened due diligence in the case of conflict-affected territories. So you will see contract clauses needing to grapple with issues such as war breaking out. Now, arbitration itself as a proceeding, or as a process, is obviously very well suited in a way to armed conflict, in the sense that you can always move your venue if your place of arbitration has been disrupted. So you can move the seat if the place of arbitration has been disrupted, or if just your venue has been disrupted, you can obviously hold your arbitration hearing somewhere else. And actually, COVID, in a way, set the stage for a lot more use of remote arbitral proceedings, as well as the use of technology in arbitration. So actually, we're probably at a moment in time where being disrupted by war and arbitration is easier to manage than in the past. Arbitration, like court litigation, is going to struggle with evidentiary aspects of war, probably will struggle a bit more than litigation, but we can envision, ways to deal with some evidentiary burdens, such as having parties use affidavits in lieu of live testimony, et cetera, other adaptations. And in fact, there are other adaptations if you do start to get cases that are sort of mass claim cases you can envision. In terms of enforcing awards against sovereign states embroiled in conflict, if any of you have tried to enforce a award against Russia right now, you'll know it is not easy. So that is obviously something that's made more difficult. And then I've already mentioned sanctions definitely interfere, and you need to be very careful in your screening protocols these days when you're dealing with any kind of counterparties that might be in a war-torn country. Finally, looking ahead. Now I have gone over, so I will just quickly say a few thoughts. Arbitration is, of course, the leading method of dispute resolution for international contracts. And that's precisely because of its neutrality, flexibility, enforceability across borders. All of these things are well suited to situations of armed conflict. At the same time, in times of armed conflict, these advantages can really be stress tested. And arbitration can become not only a commercial tool, but really a geopolitical instrument. If we look at, for example, there was a case between a Russian company and Ukraine where the good aspect of it was that the tribunal was able to handle the dispute with a low level of rancor and obviously no armed conflict involved, dealing with the alleged expropriation of an oil refinery in the wake of some political instability. That was before the current war. And I think the fact that arbitration trundled along and was eventually resolved is an example of the ability of arbitration to peacefully resolve disputes. At the same time, we see that from my lecture that there are some strong provisions that address armed conflict in investment treaty and commercial arbitration. The protective force of agreements remains strong during armed conflict. And I think the due diligence principle remains strong in the context of armed conflict. And also there's still the reliability of tribunals when courts might be unavailable. Now, there are also, though, significant gaps, as we've talked about. I think that the compensation for losses clauses are often just limited to non-discrimination. That makes them not terribly useful. Other treaty provisions all treaty provisions are bilateral and territorial. They don't help you in the case of an international conflict or an aggressor state that inflicts damage upon investments on the territory of another state. And there's no clear-cut protection for states or investors against corporate perpetrators or beneficiaries of violence. So really, I think that the picture is mixed. It's sort of a rocky terrain. And the wars that we're seeing today do raise some urgent issues about the future of international arbitration and its ability to handle these situations. I would leave this room of students with the question of what will the future of arbitration be in the context of armed conflict? Do we need new sets of investment treaty rules? Do we need new types of contracts? I think any new framework would need to address some of the issues that I've raised today, and hopefully we can have a nice conversation about that over drinks later.